हेलो गाइस, वेलकम टू माय यूट्यूब चैनल। आज की वीडियो में हम मई 2024 के फैमिली लॉ के क्वेश्चन पेपर जो कि सेकंड सेमेस्टर का है उसके बारे में, उसके आंसर्स के बारे में डिस्कस करेंगे क्योंकि कल हमारा एग्ज़ाम होने वाला है। सो आइए एक एक करके सारे क्वेश्चंस के ऊपर डिस्कस करते हैं। ये मैंने क्वेश्चंस के आंसर को फ्रेम किया हुआ है, तो इसी तरह से आप भी सभी क्वेश्चंस के आंसर को फ्रेम कर सकते हैं। नाउ द फर्स्ट क्वेश्चन इज़ डेबिटर प्रॉपर्टी. So let us move to the answer of it. In family law, property refers to asset and liability that are considered in the context of divorce, separation, or the resolution of a relationship. The legal handling of property in family law varies by jurisprudence, but there are some common principles regarding how property is divided when a couple separated. Below, I will break down some key aspects of property in family law. तो ये इंट्रोडक्शन में लिख देना ये वाला पार्ट. नाउ द क्लासिफिकेशन ऑफ द प्रॉपर्टी, तो उसमें हमें ये पॉइंट्स लिख देने हैं. मार्टियल और जॉइंट प्रॉपर्टी. सेकंड पॉइंट है सेपरेट प्रॉपर्टी. उसके बाद ये क्लासिफिकेशन इसका फर्स्ट पॉइंट होने वाला है, फर्स्ट पॉइंट. देन सेकंड पॉइंट है इक्विटेबल डिस्ट्रीब्यूशन वर्सेस कम्युनिटी प्रॉपर्टी. ये हम सेकंड पॉइंट में डाल देंगे. इसके अंदर दो पॉइंट्स हम ऐड करेंगे, इक्विटेबल डिस्ट्रीब्यूशन एंड कम्युनिटी प्रॉपर्टी. अगर आप इस तरह से आंसर फ्रेम करेंगे तो आपके डेफिनेटली बहुत अच्छे मार्क्स आएंगे. थर्ड पॉइंट है फैक्टर कंसिडर्ड इन प्रॉपर्टी डिवीज़न. उसके अंदर ये कुछ पॉइंट्स हैं 1 2 3 4. आप इनको लिख देंगे. आप चाहें तो इन सारे पॉइंट्स को लिख सकते हैं, अदरवाइज़ आप इनका स्क्रीनशॉट ले लीजिए. आप इनको एक बार पढ़ेंगे तो आपको अच्छे से याद हो जाएगा. तो ये हो गया. फोर्थ पॉइंट है इसका स्पेशल कंसिडरेशन. इसमें पेंशन एंड रिटायरमेंट अकाउंट्स, डेप्थ, बिजनेस ओनरशिप, ये आ गया. देन फिफ्थ पॉइंट है प्री न्यूपटल एंड पोस्ट न्यूपटल एग्रीमेंट. देन सिक्स पॉइंट इज एनफोर्समेंट एंड डिस्प्यूट. सेवंथ इज प्रॉपर्टी इन नॉन मैरिटल रिलेशनशिप्स. नाउ दिस इज द फाइनल कंक्लूजन ऑफ द क्वेश्चन डेबिटर प्रॉपर्टी. दैट इज our first question of 2024 question paper. Now let us move to the second question जो कि है सैपिंडा रिलेशनशिप. इसके ऊपर में हम बात करेंगे सेकंड क्वेश्चन में. तो सेकंड क्वेश्चन में ये दिया हुआ है इन द कॉन्टेक्स्ट ऑफ फैमिली लॉ Sapinda relationship refers to a specific term used in Hindu law which governs relationship between individual who are related by blood. यानी कि ये उनके बीच में रिलेशनशिप है जो कि ब्लड से सेम है. The term is most commonly encountered when discussing the prohibition degree of marriage. यानी कि जो डिग्रीज़ होती हैं रिलेशनशिप की उसके ऊपर है. जैसे कि पहले हो गए हमारे फादर, या फिर ये मान लीजिए पहले हम हो गए, फिर उसके बाद हमारे मदर हो गए, फिर फादर हो गए, फिर फादर के पेरेंट्स हो गए, मदर के पेरेंट्स हो गए. तो इस तरह से ये जो है सैपिंडा रिलेशनशिप है जो कि ब्लड के रिलेशंस हैं, उसके बारे में बात की गई है इसमें. ठीक है. और उसके बाद है डेफिनेशन ऑफ सैपिंडा रिलेशनशिप. नाउ a Sapinda relationship refer to a relationship between two individuals who share common ancestors. यानी कि जिसके common ancestors हों. The term Sapinda come from the Sanskrit word pind, which means lumps of rice, offered during the performance ancestral rites. The idea is that individuals who are related by a certain degree of bloodline are connected by a spiritual and ancestral bond, particularly when performing religious rituals like Shraddha and पितृतर्पण. तो ये हो जाता है हमारा सैपिंडा रिलेशनशिप का जो ओरिजिन है एक तरह से वो. उसके बाद है द सिंपल टर्म सेपेंडा रिलेशनशिप इज़ वन वेयर टू इंडिविजुअल आर रिलेटेड थ्रू अ कॉमन एंसेस्टर particular number of generations. A marriage between such individual are prohibited in Hindu law due to rules of consanguinity. ठीक है, ये हो गया. उसके बाद हैं कुछ डिग्रीज ऑफ सेपेंडर रिलेशनशिप, जिसमें है पहली डिग्री जनरेशनल कनेक्शन, सेकंड है प्रोहिबिशन डिग्री. ठीक है, इनके बारे में लिखना है. उसके बाद है फाइव सेपेंडर डिग्री. उस इसमें जो है पापा की तरफ से वो 5 सेपेंडर डिग्रीज होनी चाहिए और मदर की तरफ से 3 सेपेंडर डिग्री होनी चाहिए. सेपेंडर डिग्री मतलब जनरेशन 1, जनरेशन 2 एंड जनरेशन 3 इस तरह से होना चाहिए. देन है दिस मीन्स ऑफ फॉर इंस्टेंस अ पर्सन कैन नॉट मैरी देयर सिबलिंग्स को हम मतलब सेपेंडा के अंदर मैरिज में नहीं ला सकते, ना नीस को, ना नेफ्यू, ना कज़न्स विद इन दीज प्रोहिबिशन डिग्रीज. इन सबको मना किया हुआ है, ये मतलब मैरिज नहीं कर सकते एक दूसरे से. एप्लीकेशन ऑफ सेपेंडा रिलेशनशिप, इसके बारे में बात की है यहाँ पे. उसमें है मैरिज रेस्ट्रिक्शंस, अडेप्टेशन एंड इनहेरिटेंस, कल्चरल कॉन्टेक्स्ट. ठीक है, उसके बाद फाइनली हो जाता है यहाँ पे कंक्लूजन. ठीक है, तो इस तरह से हमारा ये जो क्वेश्चन था सेपेंडा रिलेशनशिप का, ये भी ख़त्म होता है. नाउ लेट अस मूव टू आवर थर्ड क्वेश्चन. देखो, अगर आप इस तरह से आंसर लिख के आओगे ना तो 100% मैं गारंटी दे रही हूँ आपको कि आपके बहुत ज़्यादा अच्छे मार्क्स आएंगे. आपको सिनॉप्सिस तैयार करने की ज़रूरत नहीं पड़ेगी. अगर आप ये वीडियो देख लेते हो एग्ज़ाम में जाने से पहले, तो आपको पता चल जाएगा कि क्या क्या पॉइंटर्स डालने हैं. नाउ द थर्ड पॉइंट इज़ partition by conversion. Partition by conversion is a concept in Hindu law specifically related to the partition of property in the context of Hindu family. It generally refers to the situation where the conversion of one member of joint Hindu family, usually to another religion, led to a change in the way the family property is treated or partitioned. The idea of rotated in the nation of joint family property under Hindu law and the impact of religious conversion on the right of the person within the family. उसके बाद है key points about partition by conversion. First point is Hindu undivided family HUF and joint family property. In Hindu family law, family property is often held by Hindu undivided family, which consists of common ancestors and his descendants. Property owned by HUF is generally considered joint property, where all members have equal rights to of it. If a person in the family decide to convert to different religions, question can arise about how the family property is partitioned or treated. Second point is effect of conversion on HUF status, and under this there is partition impact, and the one here we are having case law. In some cases, court have ruled that conversion of another religion may lead to severing the connection with the joint family, thus affecting the individual right to demand partition. However, there are also rulings where courts have allowed the converted member to continue claiming a share in the property, especially if the family property remain under the Hindu law framework. Now the third point of this is partition by conversion, different jurisdictions. एंड सेक्शन 2 के अंदर है हिंदू सक्सेशन एक्ट 1956 के अंदर फैमिली लॉ. फोर्थ पॉइंट है पार्टीशन प्रोसेस आफ्टर कन्वर्जन. फिफ्थ इज प्रिंसिपल ऑफ पार्टीशन. नाउ इट इज़ इन कंक्लूजन वी कैन से द समरी ऑफ partition by conversion. Here we read out the conclusion. Partition by conversion involves the legal complexities surrounded the right of a person who has converted from Hinduism to another religion within the framework of Hindu family law. It is nuanced topic and depends largely on the specific laws judicial decisions and religious interpretations in the place. The change in religion may impact the convert connection of HUF and their share in family property, but the issue has evolved and court often consider it fact of each cases carefully. Now the next question is legal position of Katra. Here is the answer. The legal position of Katra refers to the legal status, rights, and implication of the area in the question. Typically referred to a town or locality in India, the Katra is most commonly associated with Katra Vaishno Devi, a town in the Riyasi district of Jammu and Kashmir, which served as the base of pilgrims visited to the Vaishno Devi temple. The legal aspect or related to the Katra could pertain to a variety of factors like religious and pilgrim sacrifices. Second is administration and the governance. Third is security and regulation. Fourth is land and property laws. Fifth is environmental laws. This is about the Katra. Now the next question is maintenance pendant light. Here is the answer. Maintenance pendant light refers to a temporary maintenance guaranteed by a court to a spouse or defendant during the pendency of legal procedures such as divorce, annulment, or separation case. The term comes from Latin, uh, which means pending the litigation. Legal aspect of maintenance pendant light. First one is purpose, second is applicability, third is who can claim. Under that we are having children, husband. Fourth is factors considered. Fifth is amount of maintenance. Sixth is duration. Now the relevant legal provisions of maintenance in India, that is section 24 of Hindu Marriage Act 1955. Second is section 125 and the Special Marriage Act 1954. The enforcement of maintenance non compliance. If the person who is ordered to pay maintenance pendant light fail to do so, the court may take appropriate action, including fines, attachment of property, or even arrest in extreme cases. So, this is how the conclusion of the question maintenance pendant light. Now, the question is define gift. Can a gift be made in favor of an unborn person? Here's the answer. A gift is made in the favor of unborn person if is often a gesture of love, care, and anticipation, symbolize the desire to provide for children before they even enter the world. While the legal and practical framework around gift made to an unborn person can vary depending on jurisdiction, the general concept is well recognized in many cultural and legal systems. Such gifts typically reflect the hope and dreams of parents or gift givers to in an unborn child and can give a variety of forms ranging with from material item of financial investment. Now the type of gifts for unborn person are physical gifts, financial gifts, charitable donations, keepsakes, and the legal consideration and the conclusion. In essence, gifting to an unborn child is not an act of generosity but also a way to express hope in future, whether in the form of material object, a financial contribution, and a charitable gesture. Gift made in favor of unborn person can both Practical and emotional significance. They embody a sense of care for children's future where while offering a lasting impact on their well-being. Now the next question is there any right to maintenance out of impartation property, which is the rule of devolution of impartation property, impartable property? Here is the answer: the right to maintenance out of impartable property. Now, firstly, is the impartable property refers to the property that cannot be divided among heirs and is typically passed on as a single entity, usually in the hands of a person like ancestral, each state, and certain royal properties. The concept is often encountered in Indian law, particularly in the context of Hindu law and other customary laws that govern inheritance in princely state or religious with traditional land ownership system. Now, the rule of evaluating impartial property. First is value of the property, second, income generation, third is customary law and traditions, liability and encumbrance, fifth is legal precedents and court orders, and here is the final summary of the question. Now, the next question is write a short note on full blood and half blood relationship, and uh, and what are the requisite condition of a valid adoption? Here is the answer: full blood and half blood relationship. Short note. Here is the answer. You can read it out. In the context of inheritance law, particularly under the personal law, the full blood and half blood refers to a degree of consanguinity between the individual and significance based on the percentage in term of importance determining the legal right of heirs and succession. Now, full body relationship, and here is the half blood relationship. The next one is moral legal interpretation, and here is the conclusion. So the next short note is requisite condition of a valid adoption. Here is the full answer of requisite condition of a valid adoption in a legal process through which a person becomes the legal parent of a child who is not their biological offspring. It creates a permanent legal relationship between the adopted parent and the adopted child with all rights, privilege, and responsibilities of biological parenthood. In various jurisdictions include under Indian law, the process of adoption is governed by specific conditions to ensure that the adoption is valid and legally recognized. So here's the eligibility: age, marital status, mental and physical fitness, the adopted child eligibility, minor consent and legitimate status. Here is the relationship between the child and the adopted parent, the legal process, and the adaptation must be permanent. We cannot back the child and take our refund. It is not legal. Then ineligibility of certain persons, compliance with the adaptation law of non-Hindu community. Then here is the final conclusion of the answer. Now the next question is explain what are the sources of Hindu law, explain them fully, discuss also the contribution of litigation legislation as the source of Hindu law. Source of Hindu law are basically primary source of Hindu law, that are Shrutis and Vedas, Upanishads, Brahmins and Aryakas. Smriti is the second source of Hindu law. Under that we are having Manusmriti, Yajna Valika and Dharma Shastra. Third is customary law. Second is secondary source of Hindu law, judicial decisions, commentaries and digesties, contribution of legislation or to Hindu law, Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Adaptation and Maintenance Act 1956, Hindu Minority and Guardianship Act 1956, the Devolution of Muslim Marriage Act 1939, the Prevention of Sati Act 1987. And here is the conclusion of the answer. Now the next question is, what are the essential difference between the Mitakshara and the Yabhaga schools of Hindu law? Here is the difference. The Mitakshara and the Yabhaga school are two of the most significant schools of Hindu law, particularly in the context of inheritance law. These are two schools interpreted and apply Hindu law differently, especially with respect to the distribution of ancestral property. While Mitakshara school is prevalent in most part of India, the Yabhaga school is predominantly followed in Bengal and the part of Assam. Below is the essential difference between two schools. The origin and the founder of both the school. The Abhaga school definition of ancestral property. The Abhaga school, the right of sons in ancestral property. Now the Abhaga school, partition of property, right of daughters, concept of joint family, inheritance, will and testimonial succession, impact of Hindu Succession Act 1956, and the conclusion of the answer. Now the next question is, determine the concept of marriage under Hindu law. How far has Hindu Marriage Act 1955 changed its original concept? The Hindu Marriage Act, that is sanskara, not merely a civil contract, it is viewed as lifelong commitment that binds the husband and the wife not only physically but also spiritually. Marriage is seen as one of the key factors in Hindu must undergo in the life to attain both worldly happiness and spiritual advancement. In traditional Hindu law, marriage has been associated with certain fundamental purpose. First is dharma, second is duty, praja and rita. The Hindu marriage system was guided by ancient texts like Manusmriti, Dharma Shastra and Smritis. The Hindu Marriage Act 1955 Evolution and Change. First point is introduction of marriage as legal contract. Second is minimum age for marriage, monogamy and prohibition of bigamy, constant and marriage contract, ground of divorce, marriage registration, equality and gender justice, remarriage of widow and widowers, shift from sacrament to contract, right of freedom of woman, equality of in marriage, legal recognition of divorce, recognition of interfaith marriages, and then conclusion. Now the next question is, what do you understand by the term testimony guardian of minor, how they are appointed and what are their powers? So here is the answer of the question. Testamentary guardian of a minor, meaning appointment and the powers. The meaning of testamentary guardian. A testamentary guardian is a person chosen by the parent, typically father or mother, in their own will. Legal guardian of their minor child after their death. The term testimony refers to the will. This appointment is made to ensure the child has guardian in place of care of their welfare, both physically and legally after the death of the parents. Appointment of testamentary guardian Now the under the guardian of wards, process of appointment, will of the parent, registration of the will, effect of will, court role, power of testimonial guardian, and the power concerning to the minor of property, restrictions of power, and then the conclusion. Now the last question is discuss the general rules of the Succession Property Act of a male Hindu dying in each state. So here is the answer. The Hindu Succession Act 1956 govern the laws Hindu, Sikh, Buddha and Jains. Here is the meaning of in each state succession application of Hindu Succession Act 1956 and the general rules of succession separate. Here are the class 1 heirs, class 2 heirs, and the against and cognates, that is a short kind answer. An example of the succession cooperancy property. Before the 2025 amendment succession of property, you can take the screenshot of all this and write it down in your question. Okay. Special cases, scenario 1, scenario 2 and scenario 3. Okay, and this is the conclusion of the answer, so you can take this screenshot here. Till then, thank you so much for watching my video. I hope you liked the video and it will be very helpful in your exam. So if you like my video, then subscribe to my channel, please like the video and please share with your friends. Thank you so much for watching. Let's meet in the next video.